Welcome, everybody. I'm Steve Teskey, retired judge. I'm the host here of Justice Redesigned. Welcome. If you've already read my accompanying Justice Redesigned essay that's titled The Collapse of the DOJ and the Suicide of the Bar, you may notice that this podcast takes a different form. Now, I'm sharing this before every act because I'm not sure that every listener is starting at the previous act. So I'm playing it safe, but I want to share additional information as well. The essay presents the complete legal and ethical argument as a traditional written analysis. The podcast that follows Acts 1 through this last act, Act 5, does something different. Rather than simply reading the essay aloud, I've reimagined it as a 5-act closing argument, a dramatic presentation that gradually builds from constitutional absurdity to professional reflection, much like a trial attorney delivering a final summation to a jury, which I've done many times. Each act corresponds to a major section of the essay. Together, all 5 acts comprise the complete podcast adaptation of that single essay. Now, while additional commentary, humor, storytelling, and historical context have been woven into the presentation, the constitutional and ethical themes remain the same. Now, this approach also marks the transition from the Teskey Briefs bar card in the Breakdown of Justice series, which you can find on YouTube, to this podcast, Justice Redesigned, as well as my accompanying essay on Justice Redesigned, my Substack account. The Teskey Brief, and I encourage you to subscribe to it. It's on YouTube. You can just go to YouTube and type in the search engine the Teskey Brief, or go to www.youtube.com/ and the @ Judge Teskey, all one word. But the Teskey Brief examined these events as they unfolded. This essay and the 5 acts that accompanied it step back from the daily headlines to ask a larger and more enduring question, and it's this: what does honor require of a lawyer when power and professional duty collide? Now, whether you choose to begin with the essay or experience the story through this 5-act podcast, my moment is the same, that we remember the rule of law ultimately depends not upon institutions alone, but upon the men and women who choose to honor the oath embodied in a simple piece of plastic we call the bar card. And with that said, ladies and gentlemen, this is the final act, Act 5. Stay tuned. Welcome back. You know, I spent 35 years walking into courtrooms. Some beautiful, some run down, some with marble columns, some in converted office buildings. But every courtroom I've ever entered had one thing in common. Before the judge speaks, before the lawyers argue, before the witnesses testify, there is one symbol that quietly reminds everyone why we're here. The seal. Not the seal of the president, but the seal of the court. Because justice doesn't belong to whoever won the last election. It belongs to the law. Always has and should always be. I've often wondered, what would happen if our founders walked into one of today's courtrooms? George Washington, James Madison, Alexander Hamilton, John Adams, just to name a few. What would surprise them the most? I'm sure the technology, no doubt the cameras, the electronic filing, but I suspect there's something else that would trouble them more. The idea that lawyers might someday confuse loyalty to a person with loyalty to the Constitution, because that is the one thing they spent an entire revolution trying to prevent. The Constitution wasn't written because they trusted the government, ladies and gentlemen. It was written because they didn't trust the government. That's why we have checks and balances. That's why prosecutors have ethical obligations. That's why lawyers take an oath. That's why federal judges have life tenure. And I want to put a footnote on this and explain something about life tenure, which I think gets to my point. Some advocate that federal judges should have term limits like the president and Congress. But I proffer to you that would be dangerous to our Constitution and our constitutional democracy. Why? Because there must be a third branch that can stand up to the president and Congress and tell them they got the Constitution wrong on this one. And folks, that will not happen unless the judiciary is made strong enough to have the courage to say no to the legislative and executive branches. This is why the framers of the Constitution intentionally created a third branch that is undemocratic. That's right, undemocratic, and appointed for life. To do anything less is to install justices who will be afraid to stand up and the other branches get it when the other branches get it wrong, in fear that they will be voted off the court. If we make that third branch democratic, they can't have the courage to do what is the right thing to do without fear they're going to lose their job at the next election. Now, before I move on, I offer this for you to ponder as I think some supporting evidence as to what I'm saying. In 1954, a Southern congressman lobbied President Dwight Eisenhower to appoint someone who would be sure to uphold the Plessy versus Ferguson decision. You may recall the famous 1890s case which affirmed the continuation of segregation in the South, the separate but equal facilities. The case was about to be decided in Brown versus Board of Education. Most of us know what happened in that case, but bear with me. The Chief Justice had just passed away, and Brown was about to be decided. So Eisenhower chose Earl Warren, the former governor of California, a strong Republican conservative, right? Now, I cannot say for sure, but I have very strong suspicions that Eisenhower made at least a half-hearted effort to give the Southern congressmen what they wanted, because it was Earl Warren who issued the executive order in California during World War II, at the beginning of World War II, to intern Japanese American citizens in prison camps. Wow. See, the theory here being that if he was willing to do that, he would likely decide to uphold Plessy. But we all know the rest of the story. He did not. And went on to forge a unanimous decision in Brown versus Board of Education to hold that segregation is unconstitutional. In fact, one of those justices, Justice Hugo Black, was on the roll of the KKK when he was a U.S. Senator out of Alabama. Now, I don't want to discredit Hugo Black, God rest his soul, who I admire greatly. But back in those days, folks, you could not get elected to any position unless you were a member of the KKK. That's a fact. And if you read his, not his autobiography, but his biography, he hated the KKK. Of course, he couldn't say that then because he needed to get elected. But anyway, we also know that Earl Warren ended up presiding over a Supreme Court that would become the most progressive Supreme Court in American history to date. Now, who knew? Except that when the shackles of voting for what your constituents want are broken and you are free to vote your conscience, well, that's what happens when your job is to decide what is right and wrong for life, and you are no longer influenced by your voting constituency. All right? Now, with all that said, every safeguard in our system exists because the founders understood one timeless truth. It's power, without restraint, eventually stops restraining itself. Throughout this series, I've talked about prosecutors, judges, lawyers, ethics, courtrooms, resignations, investigations, politics, but none of those were ever the real subject. The real subject has always been trust, because trust is the currency of justice. You see, without it, jury verdicts become political. Court rulings become suspect. Prosecutors become feared instead of respected. Judges become targets instead of guardians. And eventually, citizens stop asking, what does the law require? And instead, they begin asking, who's in charge? That is how republics begin forgetting themselves. And I've been fortunate. I've lived this profession from almost every seat in the courtroom. I've stood at counsel tables as a prosecutor. I've stood at a counsel table as a trial attorney in many civil cases. I've sat behind the bench as a judge, both in juvenile court and superior court, doing both juvenile and adult matters of all kinds, criminal, civil, you name it. I've taught young lawyers, okay? I've testified before Congress on 4 occasions. I've worked with communities across this country trying to build justice systems worthy of public trust. I've sat on criminal justice reform commissions, child welfare reform commissions. I've seen the law at its best. I've seen it, ladies and gentlemen, at its worst, which is why I can tell you this with complete certainty. The greatest lawyers I've ever met were not the smartest. Lord knows I'm not saying I'm the smartest, right? But you can recognize smartness and not so smart. Some were smart, many weren't. They weren't the most famous. They weren't the wealthiest. They weren't the most politically connected. They all shared, though, one quality. When the pressure came, they remembered who they served. It wasn't the governor or the president or the attorney general or the loudest voice in the room. It was always the law. That is the profession at its finest. One day, Donald Trump is no longer going to be president. Todd Blanche will no longer be attorney general. Every administration represented in this series, Republican and Democrat alike, will become another chapter in a history book. Politics always has an expiration date, but the legal profession, folks, does not. Every generation inherits it. Every generation reshapes it. Every generation decides whether to leave it stronger or weaker than they found it. And that's why this series has never been about predicting who wins the next election. It has been about something much more important, whether the next young lawyer walking across a stage, raising a right hand, receiving his or her first bar card, will inherit a profession still worthy of that oath. That's what concerns me. Because here's the truth. The Constitution, well, folks, it can't defend itself. Statutes, the laws can't defend themselves. Court opinions cannot defend themselves. Justice cannot defend itself. Only people can. Only lawyers, only judges, only citizens like all of you. Robert Jackson, former Justice of the Supreme Court, once warned that the prosecutor possesses more control over life, liberty, and reputation than any other person in America. He understood something extraordinary. And you see, he too was a prosecutor. Okay? He too was an attorney general. The greatest danger wasn't that prosecutors would become powerful. It was that they might forget why they were given that power in the first place. I began this series by talking about a small piece of plastic, a bar card. Funny, isn't it? After all these months, after all these episodes on my YouTube podcast, The Teskey Brief, after everything we've discussed, we end exactly where we began. Because that little piece of plastic isn't really plastic at all. No, folks, it's a promise. A promise made to the public, a promise made to every judge you'll ever appear before, a promise made to every client who trusts you, a promise made to yourself. And now I am talking to the young lawyers out there. That's when the moment comes. And eventually it comes for every lawyer. You will choose principle over pressure, judgment over loyalty, truth over convenience, because in the end, history will not remember how loudly we defended power. History will remember whether we defended justice. And ladies and gentlemen, with that, the people rest. I'm Judge Stephen Teskey, retired. This has been Justice Redesigned. I thank each and every one of you for listening and joining me. And until the next episode, I wish everyone to be safe and look to see you soon.